1969 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာ84 Criminal Appeal before ဦးကျော်စန်းဦး and ဦးသက်ဖြေ Judges ဦးဘစိန် Appellant vs ဦးသိန်း Respondent ဤစီရင်ထုံး Audio book ကိုထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးမိသားစုကစီစဉ်သည် Code of Criminal Procedure Appeal under Section 476B Application for Succession Certificate Non-compliance with provisions of the Succession Act whether the court has jurisdiction to grant a certificate in respect of a house site ultra-vires and illegal proceeding whether the provisions of Section 476 of the Code of Criminal Procedure will be attracted if an offense under Section 193 Penal Code were committed in the course of such proceeding. Hell, the true copy of the respondent's application for succession certificate bearing the seal of the court produced before us does not show the particulars required in clauses B, C, E and F of subsection 1 of Section 372 of the Succession Act, and a court has no power to grant a succession certificate except upon an application complying with the provisions of the Succession Act. The debt and securities mentioned in Section 372 1F do not refer to immovable property. A debt for the purpose of a succession certificate is a certain sum of money now payable or becoming payable in the future. Security is defined in Section 372 of the Succession Act. It means inter alia, promissory note, debenture, stock, bond, share in a company. Hence, the issue of a succession certificate to the respondent in respect of the house site being number 145 in Kanshi Quarter was null and void. The court has no jurisdiction to grant such a certificate. Mountain Mount vs. Mount Law, 3 Burma Law Times, page 153, referred to. A proceeding in which a judge acted without jurisdiction being ultra-vires and illegal, it is no proceeding at all under Section 476 or 476A. In order to prosecute the respondent for giving false evidence, the proceeding must be a judicial proceeding. If during the course of proceeding, which was ultra-vires and illegal, an offense under Section 193 was committed, it cannot be said that it was committed in or in relation to a judicial proceeding so as to attract the provisions of Section 476 of the Code of Criminal Procedure. U A Mao for the appellant, U San THEIN for the respondent, U Josan U, judge. This is an appeal under Section 476B of the Code of Criminal Procedure against the order of the District Judge of Daungji, dated 31st October 1967, in his criminal miscellaneous case number 2 of the 1967, declining to hold an inquiry against the respondent, who is no other than the nephew of the appellant and who, on 17th November 1947, obtained in civil miscellaneous case number 6 of 1947 of the Code of the Assistant Superintendent of Civil Justice Daungji, the record of which we are informed by the advocates for the parties has now been lost. A succession certificate which was subsequently revoked on 7th April 1967 in civil miscellaneous case number 11 of 1966 of the District Court of Taunji, and to make a written complaint signed by him as the presiding officers of the court, District Court of Taunji, against the respondent for making false and untrue statements punishable under Section 193 of the Penal Code in his application for succession certificate in the aforesaid civil miscellaneous case number 6 of the 1947, that on the death in June 1944 of Do Ning, the mother and grandmother respectively of the appellant and the respondent, he, respondent, being the sole heir under the Burmese customary law, was entitled to the succession certificate in respect of the immovable property, being house site number 145 in Kanshi Quarter, Taunji, on which were some buildings which were burnt down by Chinese troops in 1942. The three main points presented for our consideration are: 1. Whether it could be said that an offense under Section 193 of the Penal Code or any other offense was committed by the respondent to attract the provisions of the Section 476 of the Code of Criminal Procedure in the proceedings, being civil miscellaneous case number 6 of 1947, where the succession certificate was granted illegally under Section 377 of the Succession Act to the respondent in respect of immovable property referred to above on the false and untrue statements made by him, and where no full particulars as required by Section 372(1) of the Succession Act were given in the application made by him for the certificate. 2. Whether it is expedient in the interest of justice that a complaint should be made after an inquiry against the respondent when the matter may have arisen out of malice or private grudge, and 3. Whether the delay of about 19 years in making the application to move the court to lay a complaint is fatal. It will be more convenient to deal with the first and second points together. The true copy of the respondent's application for succession certificate bearing the seal of the court produced before us does not show the particulars required in clauses B, C, E, and F of subsection 1 of Section 372 of the Succession Act. The lower court was also fully aware of these defects in the application. A court has no power to grant a succession certificate except upon an application complying with the provisions of the Succession Act. In Maung versus Maung Law, it was held that the application must specify each debt and security in respect of which a certificate is asked, and the certificate, when granted, must likewise specify each debt and security covered by it. The debts and securities mentioned in Section 372(1)(f) do not refer to immovable property. A debt for the purpose of a succession certificate is a certain sum of money non-payable or becoming payable in the future. Security is defined in Section 372 of the Succession Act. It means inter alia, promissory note, debenture, stock, bond, share in a company. Hence, the issue of a succession certificate to the respondent in respect of the house site being numbered 145 in Kanshi Quarter was null and void. The court has no jurisdiction to grant such a certificate. Now the point which arises from consideration is whether the respondent can be prosecuted for making false and untrue statements in a case where the procedure adopted by the court was ultra-vires and illegal, or in other words, where the judge had no jurisdiction to pass the order he did. That is to say, to grant succession certificate in respect of a house site which was neither a debt nor a security. There is no denial that the statements were untrue, if not false. The respondent, however, explained that he, being the eldest of the 5 children left behind by his deceased mother, none of whom would object to the grant of the certificate to him, and that his uncle's appellant's whereabouts being untraceable, he claimed himself to be the sole heir of his deceased grandmother, THEIN, under the Burmese customary law. He submitted that, due to circumstances arising out of the war, he could not trace his uncle appellant and his grandmother, and he bona fide believed them to be dead. As a matter of fact, the grandmother was still alive when he obtained the succession certificate, and her death certificate shows she died in Rangoon only on 20 July 1956 at the age of 78 years. Prima facie, she was ordinarily residing in Rangoon at the time of her death beyond the jurisdiction of the District Court of Taungji, which may not therefore have sufficient authority to entertain the application for the grant of succession certificate. He further submitted that there was neither fraud nor intentional concealment. Otherwise, he would not have agreed to the revocation of the succession certificate, which he later found out to have been inoperative and void ab initio, having been obtained under a mistake of facts. We have studied the various authorities on the point, and we are clearly of the opinion that the proceeding in which a judge acted without jurisdiction being ultra-vires and illegal, it is no proceeding at all under Section 476 or 476A. In order to prosecute the respondent for giving false evidence, the proceeding must be a judicial proceeding. Under Section 193 of the Penal Code, for example, where M instituted his civil suit against B and C, a decree was passed against B only, and subsequently the court reheard the suit de novo on the application of C, against whom the suit was dismissed, and laid a complaint under Section 193 of the Penal Code against B after dismissing the whole suit. It will be seen that C had no locus standing to apply to reopen the suit de novo, and the court's action being ultra-vires and illegal, B could not be said to have committed the offense, as the proceeding was such under which no evidence could be legally taken. We may give another instance. The district judge inquiry into a charge of unprofessional conduct of a pleader committed in the township court is ultra-vires, because under Section 14 of the Legal Practitioners Act, it is only the presiding officers of the court in which the misconduct was committed who can hold the inquiry and lay a complaint under Section 476 of the Code of Criminal Procedure against a witness for perjury. The district judge has no jurisdiction to hold the inquiry and to lay a complaint. It may be technical, but it must be remembered that we administer the law according to the established rules. We therefore ruled that if during the course of proceeding, which was ultra vires and illegal, an offense under Section 193 was committed, it cannot be said that it was committed in or in relation to a judicial proceeding so as to attract the provisions of Section 476 of the Code of Criminal Procedure. This goes to the root of this appeal. The parties are closely related and there are many litigations between them, leading us to form an opinion that they obviously are not on good terms and that this appeal arose out of malice or private grudge and not in the interests of public justice. The question whether a complaint should be made under Section 476 of the Code of Criminal Procedure is almost invariably a matter of discretion. Ordinarily, this court is reluctant and is loath to interfere with the orders passed by the courts below. Every case of perjury need not necessarily result in prosecution. It is the policy of the law that primarily serious prosecutions should not be left to private persons but to the state in the interest of justice and not to satisfying the private grudge of a litigant. It has been said, "The thought of man shall not be tried for the devil himself, no, not the thought of man." But there is always a presumption of malice whenever a private party, especially a close relation, applies to the court to prosecute his opponent, who is his own relation. We consider that the views we expressed above on the first 2 points finally dispose of this appeal, and we need not burden our judgment by attempting to answer the remaining point on the question of delay in applying to the court to lay a complaint against the respondent. In the result, the appeal fails and it is dismissed.